And welcome back. Joining us this morning for our first conversation is the Attorney General of Belize, none other than Anthony Sylvester. He's here in person to discuss with us a range of issues. Good morning, AG.
Good morning. Good morning, Ms. Daly. Good morning, Isane. Thank you for having me.
How's it going?
It's been quite a busy time since I've taken on the challenge of being Attorney General. I think even myself here as a practitioner, I didn't appreciate the extent of the role and the job of an Attorney General. The Attorney General's office and the ministry is staffed by very competent and very skilled professionals. It includes advising government and at times statutory bodies of matters. It includes a litigation unit which is responsible for defending the government in, and at times statutory bodies in all matters which are brought against them. Involves drafting all laws, all litigation. And so one may not appreciate, but when there is a House meeting and there are various legislations which are introduced and which are sought to be passed, the work behind that goes, takes place by those persons at the Attorney General's ministry. So policies with respect to any area of life, whether it be immigration, whether it be in terms of the environment, fiscal matters, those policies eventually have to be crafted into laws to regulate that specific subject area. And persons who are drafters, they have the unenviable task of having to take policy on any specific area and come up with a legislation that would meet the required needs, and as well be able to comport with what obviously has to be regional or international standards. There are model legislations that one could draw on, but of course the unique situation or circumstance that obtains in Belize would require a tweaking, and of those specific type of legislation. But indeed, it's a very involved level of work, and it's something that I am totally enjoying. No?
You are the country's chief legal advisor. That's the office that you hold. Do you believe that for you it has been somewhat of baptism by fire in terms of jumping into the thick of things and finding your footing while doing so?
So I must commend my predecessor. She has left in place a very effective system in terms of being able to have the various workload of the Attorney General's ministry being able to be conducted in a manner which allows for room for breathing and for space, and as indicated earlier, that is done via the various units in the Attorney General's ministry. And as well, constitutionally, the Office of the Attorney General is responsible for all legal matters within the country. Curiously, when you, for instance, would read that part of the Constitution, so within the part that deals with the Attorney General, you have the DPP's office, for instance, and the DPP's office is an autonomous, independent body. But there's a proviso which indicates that, well, as the DPP's office has powers for with respect to prosecution, it is subject to, of course, the Attorney General's ministry or Attorney General's office. Of course, that has never been utilized, but just to say that in terms of the constitutional significance of the office, it is indeed great, and there is indeed some baptismal by fire, but it has been an extremely rewarding and experience. It's not any day someone is being able to be appointed Attorney General, so I take the challenge and the appointment as more of a blessing than
When you look at the three branches of government, you look at the executive, the legislature, and you look at the judiciary, you're functioning from the point of view of the legislature at this point in terms of drafting laws and policies and what have you. But as a lawyer, you've been also functioning within the judiciary in terms of representing persons who come before the court. How do you see that engagement at this point between those two bodies?
The AG isn't a member of the
It's still part of the executive?
It's part of the executive as the chief legal advisor. So in terms of the legislature's role, in terms of drafting laws, having laws that address particular needs, whether it be, as indicated, criminal matters, regulating family matters, environmental matters, climate change, new evolving eras where, for instance, there are no regulations or no laws, and so what the various ministries, they obviously would have a policy that would need to be enacted, and that is where the AG's ministry would come in terms of taking that policy and finding and taking it to a particular law. Then the legislature, thereafter, they enact that law. So our role is we receive instructions and we act on instructions, and the legislature takes it from there. No?
Was there any set goal that you had prior to assuming the role of Attorney General that when you got this position, that was your intention to complete?
So one of the things Isane was indicating earlier, I had the good fortune of being a practitioner, being in the courts, and so one of the things that I wanted to do and to continue, again, I need to come in and pay tribute to my predecessor in terms of putting in place and implementing quite a number of fantastic reforms with respect to the judiciary, with respect to how matters are to be conducted. And in respect to myself, one of my focus is in terms of criminal justice reform. So as you will appreciate, whenever a crime is committed, there are so many persons who are directly and indirectly impacted. The victim, of course, as well, the police department and the citizenry on a whole, whether it be an extreme violent crime such as murder, but similarly very grievous crimes such as sexual assault and sexual offenses. So these crimes, they in particular with sexual offenses, they remain and have such a traumatic and psychological impact on the victim, even so many years later. And so one of the things that has to be that has always seemed to plague the system is having matters be completed within a time, that they are resolved within a time where you would have the victim and as well as the accused, the defendant, because they are presumed innocent until there's a final resolution, that is done within a reasonable time, that is done within a time period where both parties are able to get on with their lives, within a reasonable period. And
that has been the biggest challenge.
That has been an extreme challenge. And I was reading a study the other day, and perhaps maybe it's the way our system initially was developed. So our system initially was developed where you would have persons, every person who's charged with an offense, they proceed on a basis that, well, I'll have my day in court. And having a day in court would mean that you actually go through a trial. But as you will appreciate, a trial is indeed a lengthy process. Say, for instance, a trial could last a week. So imagine a trial lasting a week. There are 52 weeks in a year. So strictly speaking, a particular court then could only dispose of 52 matters for a year. But yet, you would find that there are hundreds of matters that a particular court may have on its calendar. So therein you begin to see where the problem lies, and so you have to develop and devise a mechanism to try to work within the existing system and try to address that. No?
What you're speaking to is the perennial backlog of cases
Yes.
before the courts.
That is so.
And I've covered quite a number of ceremonial openings of the Supreme Court, now the High Court, where every year that is what is on the table. Members are saying, look, you have this backlog that despite how much we try to shave off a number of these matters, they just keep mounting.
Yeah.
And up to fairly recently, that was one of the concerns that was brought to the fore, that you still do have cases that are, just perhaps languishing. And when we look at the idea of justice, meting out justice and what have you, it should be done in a timely manner, right? That's the primary aspect of it, that it should be, for it to be effective, it has to be done in a timely manner, as you alluded to earlier, where both the victim or the perpetrator or the persons involved in the matter are able to see or realize the final outcome. Why are we not there yet, despite all the efforts that we're making in an attempt to address this matter properly?
So, indeed, as indicated earlier, the courts which ultimately have the deal with these matters, they have written in what is regarded as judgment or decisions with respect to the impact, the adverse impact of having these matters languishing. You have situations where witnesses who may initially have been forthcoming and who would have wanted to, who were very positive at the outset to participate in the process. After a couple of years, you won't have that verve or that drive again for multiple of reasons. As well, the stigma that is attached to a person being charged and having a matter before the court, that remains until and unless his matter is disposed of. The situation is not unique to Belize. The situation is one that is indeed found in just about every criminal justice system. And so one of the things that we are seeking to do within the government is, and cabinet press release was issued last week, which indicates a number of criminal justice reforms that are being proposed. And we will, in short order, be sending out these draft bills for consultations with stakeholders, which would include the judiciary, the police, and community rehabilitation department, and those, the bar association, those stakeholders. But to your point, so in addressing the backlog, what experience has shown is that, and I was alluding to it earlier, you would never be able to have all matters be tried, or all matters cannot really be tried. If we take that approach and if we continue to operate within that context, it will never go away. So what we are
justice
proposing,
delayed is justice denied. So if you have someone who is on remand for an inordinate period of time, not knowing if they're coming or going in terms of the matter that's before the court, you have someone just sitting there who may very well be innocent of a charge.
Yeah. So to address that, the fact that you have the continuum within which we operate, I think, on the perspective which has for many years we have been operating within the criminal justice system, would have to change. And it is something that has been adopted in other countries, such as in Trinidad, Guyana, Bahamas, where you have what is referred to as a plea discussion and pre-agreement system, where it's not, it doesn't exist in Belize, it's not practiced in Belize, but appreciating that it is somewhat difficult and impossible to have all matters have a full trial. And indeed, there is no need for all matters to have a full trial. So for instance, just by way of example, so we came out of COVID, but then you had, for instance, an offense such as a COVID regulation. I mean, it was
mask or curfew.
It was an inordinate waste of resources to actually have what persons actually felt, and they have the constitutional right to actually go through a trial. Let the police come and let the police establish that I indeed did not have a mask. So, and one of the reasons why that takes place is because quite often, and it is the case that the court's ability to sentence is rather restrictive to either a custodial sentence or a fine, in some cases a community order. So what is being proposed is that you would now expand the available sentencing options for the court. And what that does is that incentivizes the accused and all parties, including lawyers, to say, listen, man, Isani, you have an option, for instance, that maybe you may get a suspended sentence, you may get a conditional sentence. And those options, what it does, it incentivizes you. So like, man, it makes sense if I go through this inordinate process. I could get this matter we dispose of, and I could get on with my life. So doing things like that, having mechanisms within the system like that certainly assists. So you have much more available types of sentences, which would then encourage people to plead guilty, accept their responsibility, and then to move on with their life. Allied to that, there is also a proposed legislation with respect to criminal records. So there's a proposed
expungement of criminal records.
Criminal records and rehabilitation of offenders, because there has to be a dual focus. It is important in any society that persons, after they've served their sentence and they've paid the society for the wrong that they've done, that they are able to move on without that stigma continue to.
Well, I'm glad that you raised that, because when you look at someone who has had a criminal past, as you've mentioned, they've served their debt to society and what have you, there should be perhaps a reasonable time within which the record can be expunged, so that when that person is seeking employment and they're asking for a criminal record, you're not carrying that old weed charge from the time when you were 18 and now you're 42 and that's still on your record. I mean, I know that they've adjusted that for cannabis, right?
Yes.
Cannabis possession of a certain quantity. But the point is that you still do have certain blemishes, so to speak, using it loosely, on your record that can be done away with within a reasonable time for you to move on with your life, as you said.
And indeed, there is a stigma. I mean, that if you have a police record, you could just about forget it. No one will.
Precisely.
You're basically unemployable, and so it basically is counterproductive, because so it is, you have someone who has served his debt to society, but that stigma remains, and he's or she is unable to be employed. So chances are that person may find him or herself, in the criminal web once again.
Yeah.
So as to
you're completely disenfranchised from work.
Exactly. So confronting that obvious problem, there is the government intends to enact a proposed rehabilitation of offenders and expungement of records act. So there has to be two aspects to it, as I indicated earlier. It's important that it cannot simply be a situation where your record is expunged. The law that is being proposed and to be enacted will require that you, between that period that is referred to as a rehabilitation period, that you don't reoffend.
Yeah.
So if it is, Isani, that you had a criminal record 10 years ago, but I mean, you've been reoffending.
You're a repeat offender.
You're a repeat offender. Then
that can't be wiped.
That can't be wiped off, and it ought not to be wiped off. So it's not an automatic wiping off, and then you go ahead and you continue to reoffend. So it's an opportunity in which an important mechanism to ensure that persons are given a second chance, a second opportunity after having, and there are many instances where people commit offenses at a very young age, and they commit offenses without appreciating the stigma that actually will carry through with them, you know, when they
If you're young and naive, I'll use that description. You're 18 years old, right? Back in the days, you get caught with a stick of weed. You get caught with a firearm, for instance. You were charged, you went through the process, you were either given a custodial or a non-custodial sentence, you've dealt with that. 10, 15 years down the road, you've fully reformed as an individual, perhaps went back to school, perhaps has had a family and you're dedicated to that. You're now interested in applying for a job, and then you go, because it's a requirement for you to submit a criminal record, you go and you do so only to find out that is still there. Now, the potential employer does not see all the reform that you've been through. They don't see that, oh, you're a family man, you completed school, so on and so forth. They only see, oh, well, in 1998, there was this firearm charge on your record. You're unemployable now because we don't want to take that risk on you. Those are the real effects of what's happening with regards to certain charges remaining on your criminal record long after the fact.
So you touch on a very important aspect as well. So the existing regime with respect to expungement, there is a existing regime, but what the proposed law seeks to do is it seeks to make better provisions for it. So as things stand, there isn't, strictly speaking, a mechanism which you could apply and you could have your record be able to be expunged. Or there isn't a body as such which regulates this. So under the proposed legislation, there would be actually a board which regulates this, where it would include persons from the judiciary, persons from the Human Development Office, and other relevant stakeholders who, again, because you want to ensure that whilst persons' records will be expunged, that they as well, they did not recommit and that they indeed complied with that rehabilitation period which the law will require. So if you have served your time, either a fine or whatever, and you're required to have a 3-year rehabilitation period, a 3-year period where you're not to reoffend. There has to be a mechanism in place for persons to regulate this. You don't personally have that, and so those mechanisms will be put in place. And again, it would allow for more quicker, a more efficient way to manage this very, very important aspect of our lives. No?
Since we're on the topic of offenses, AG, I wanted to bring up the recent amendment to the criminal code that has to do with threats now being a serious offense. Could I get your thought on that?
Sure. So this amendment comes by way of what is a real unfortunate situation where you have persons, public officers, teachers,
members of the media,
members of the media, who, in the course of your work, you persons may make some very bold and very grievous threats, and so, as a government, we felt that the time has come for, the government and as a country, for us to send a strong message to all and sundry that, look, persons, professionals who are doing their job, they should not be subjected to such behavior by members of the public. And that, so the law, which will be amended, persons who in fact do that, they would be liable to imprisonment of up to 5 years. That doesn't mean that they will be, on every instance, be...
Well, there's still burden of proof, because I, as a media practitioner, for instance...
But that's one of the easier offenses to prove.
Okay.
That's one of the more easier offenses to prove, that someone makes a threatening, issues threatening words or makes threatening words to you. It is, I have found in my experience, one of the more easier offense to prove. But the point being made is that persons and members of the public cannot engage in that type of conduct and that type of behavior. And so, as a government, we appreciate that the time has come, and that we need to send a very strong signal.
Well, one of the charges that has been brought recently is the fact that you do have prosecutors, you do have other persons within the justice system who are going about doing their job, and you have persons on the stand who are levying threats. You know, it makes for a very, very difficult situation for anyone who has to leave that courtroom and go home on their own, knowing that someone just threatened my life or my well-being.
That was also a factor in a consideration in the proposed legislation, that persons in the judiciary, prosecutors and legal officers, they do and they perform such a very important role for not only the government but for the country. And so they need to ensure that there's some level of peace of mind in conducting their work. You know, the law has to therefore, and it has to be shown to the members of the public that you know, we as a country, we should respect and we should have regard for professionals and persons who are conducting their work, you know, in a public space, and that they as a country, that we will not take that lightly when persons seek to threaten public officials, public officers, persons in the media, judicial officers, prosecutors, legal officers. And there are a couple other persons, other categories that escape me at this time. But certainly that was the rationale behind that piece of legislation.
I mean, I'm sure some of our viewers may wonder if social media threats would also be included in that.
Yes, a threat is a threat, and so it doesn't have to be verbal. It could be as well in written. So if someone sends you a written
a text message,
which is the normal way in which persons conduct, communicate these days. I mean, that is evidence, and that is a basis for which a charge could be brought against such persons.
I want to use our remaining time to touch on some other matters.
Of course.
Including what was seemingly a sick out a few weeks ago by 5 of 11 prosecutors from the DPP's office, and how the matter was dealt with in terms of your office and the financial secretary sitting down with members of the prosecutors' corps, if I could use that description, to resolve this matter. What were some of the primary concerns that you felt were necessary to be addressed immediately? Because security was one of them, as far as I'm aware, and of course, compensation in terms of their responsibilities when you look at others within the judiciary who are being well paid, so to speak.
So that's a very good question, Isani. So the meeting that was had a couple of weeks ago did not only include prosecutors, but include as well persons representing the magistracy, the lower judiciary, so to speak. And so the issues relating to, as the financial secretary had indicated, one of the issues that always one has to keep at the forefront of the mind is ensuring that there has to be equity, and it has to be with respect to whatever, when we speak about salaries and whenever we speak about compensation, that is something that has to be borne in mind, that it has to be equitable. And so that was a concern that was raised, and we believe, obviously, for obvious reasons, we will not be able to disclose the extent of the conversation and the extent of the discussion, but it was something that was taken on board, and it's something that the government appreciates needs to be addressed and will be addressed.
Was it something where at the end of that conversation that the parties who felt aggrieved in the first instance were satisfied that their concerns were being addressed and taken seriously?
I would want to think that we, as a government, we operate on a good faith, and so in terms of trying to address whatever issue, we address it on a good faith basis, and we deal with it within the existing mechanism that exists for resolving any type of issues, and that, I believe, was what was done, and I would say that the matter has been addressed.
Let's go back a bit then. We were discussing the use of threatening words earlier, and in this case we'll limit it to prosecutors and other legal officers. And the fact that they are saying, well, look, we don't have any security being afforded to us when we leave the courtroom or when we leave our offices at the end of the day. And if someone has levied a threat against you, obviously you're more cautious then than before based on what transpired in the courtroom or in the conduct of your job. How was it resolved or addressed when they were saying, well, we need either an allowance to be able to pay for our personal security or for security to exist in terms of their going and coming from work?
So, as you will appreciate, so if you are addressing, if you have a security issue, it doesn't augur well for that to be debated and discussed within a public space. Okay. Persons who would be, who are the potential perpetrators, they would know and understand, okay, what are the mechanisms that have been put in place, and it is for that reason that I don't think that it is wise and it makes sense for us to discuss that. No?
All right. Well, AG, we want to thank you so much for joining us this morning
well.
and giving us feedback on all of our questions.
Thank you very much, Ms. Daly. Thank you very much, Isane.
No problem, brother.
Alrighty, we're going to take a break, and when we come back, we'll be speaking to recipients of the Chevening Masters Scholarship Program. Don't go away.